to Bloomberg Quint Live. Now, the Supreme Court today struck down a circular issued by the Reserve Bank of India on February 12, 2018. The circular laid down a framework for the restructuring of debt. The contentious feature of that circular is that it directed banks to file insolvency petitions in the event they fail to achieve a debt restructuring plan within 180 days. Well, first companies from the power sector and then companies from several other sectors such as textile and sugar objected to that circular, arguing that the RBI had exceeded its remit in pushing banks to file insolvencies. Today, the Supreme Court agreed with that argument. To what extent does this curtail the RBI's powers, and how wide is the impact of this Supreme Court decision? To answer those questions, I'm joined today by a senior advocate, Sajan Puvaya. I'm also joined on the show by Nilang Desai, partner at AZB. Mr. Puvaya, thank you very much for joining us, and Nilang, thank you to you as well. Gentlemen, this case comes down to how the Supreme Court has read Section 35AA. I don't mean to be very technical, but the reason why I'm bringing this up right up front is because the entire judgment focuses on the reading of this Section 35AA, which is a section or a provision in the Banking Regulation Act from which the RBI draws its powers. And I just want to read out the section for our viewers before I get into questions to you, Mr. Puvaya, and to you, Nilang. The section says this: the central government may by order authorize the Reserve Bank to issue directions to any banking company or companies to initiate insolvency resolution process in respect of a default. Now, as you read that section on your screen, please note two things. The central government may, as the text says, and the second part of it is in respect of a default. Now, the Supreme Court found that the February 12th circular was flawed in both these manners, that it did not draw its powers from a central government authorization of sorts or order of sorts, and that second, it was not in respect of a default, that it was a circular that laid down the framework for all debt restructuring. So it was general, not specific. Now, Mr. Puvaya, if I may ask you, the flaws lie in Section 35AA, and effectively, by saying what it has, the Supreme Court today has told the RBI that unless the central government directs it, the RBI can no longer ask a bank to send a corporate debtor to insolvency, correct?
Correct in a sense, because we should remember that the entire dispute began contextually when the power sector actually raised this issue in May of last year in Allahabad. And it has been a long journey from Allahabad to the Supreme Court. But what the Supreme Court has actually said is that, let's be very clear, it does not find fault with Section 35AA as such. It does not say that the section is unconstitutional and therefore that must be struck down. It has actually indicated that there is nothing wrong with the section per se. But what it finds fault with is the exercise of the power of the RBI under that section, because it indicates that for the RBI to exercise power under Section 35AA pursuant to a direction or a notification from the Government of India, it has to be specific. It has to be for a default. It must actually therefore have a rational indicator in terms of what it intends to do. It can't be a scenario saying that all people with dark hair, now come on, put them in insolvency, or all people with white hair after September of this year, put them in insolvency. So it was that scenario of a power that is carved out in a statute which gives the regulator a particular power to do a particular thing in respect to a default, and that too after an authorization from the central government. When such is the contour of power, the limited power that is given, the RBI could not have gone ahead and issued one circular to indicate that irrespective of sector, irrespective of industry, irrespective of the position that you are in, you will necessarily go through an insolvency proceeding come September, that is come 180 days from February.
Okay, so Mr. Puvaya, I do want to tell our viewers that you did represent several of those sectors or companies in those sectors that had agitated against this Feb 12th circular. I also want to ask you a very simple, short question. Does this mean, after this Supreme Court decision, that here on, unless the central government has explicitly asked the RBI to seek or ask a bank to move, an insolvency petition against a corporate debtor, the RBI will not be able to do so?
Yes and no. Let me just wordsmith it a little. You are right that yes, the entire fulcrum of this litigation started from the power sector, and I represented them through from Allahabad to the Supreme Court. There were a lot of senior advocates representing various sectors, including the power sector and power associations. But what the judgment now entails is the following: that if you really, irrespective of sector, if you really want to force the banks and compulsorily mandate the banks to take a particular company through a resolution process under the Insolvency and Bankruptcy Code, that exercise of power must be specific in the sense that it must be rationally oriented to a default, which is a case. The central government may notify, indicating that, okay, in the case of A, B, C, D defaults, I am authorizing the Reserve Bank of India to undertake certain actions. But then the Reserve Bank of India must, by a circular, indicate to the bank saying that I am directing a bank or a consortium of banks to necessarily take case A to the insolvency process under the IBC. It can't be a scenario where the RBI says that I am now directing the banks, irrespective of who you are and where you are, for all debts above a particular value in 180 days or in 130 days or in 90 days, you will necessarily take them through an insolvency process. That discretion or that overarching power does not exist and is no more available with the Reserve Bank of India. It never had it. It exercised it on the guise that it had it. The Reserve Bank, the Supreme Court has now said that you never had it.
Okay, I want to ask you one more question before I go to Nilang for his interpretation of this order. And that, sir, is the fact that there is some irony at play here, right? Because Section 35AA was inserted in the Banking Regulation Act in the year 2017, if I remember correctly, first promulgated by an ordinance and then inserted in the BR Act through an amendment, a parliamentary amendment to the Act. And effectively, it was done so to give the RBI sort of enhanced powers. Because if you look at 35A, and for those who are conversant with this aspect, 35A does empower the RBI to do a variety of things with regards to banks already. But there was some worry or concern that maybe 35A was not specific enough, and therefore 35AA was inserted to allow for RBI to direct banks to take corporate debtors to insolvency. Now, ironically, the very same 35AA has come to circumscribe the RBI's powers.
Not really, if you look at it from a larger perspective. Let's look at how the Supreme Court has dealt with economic legislations over a period of time. Let's look at the Insolvency and Bankruptcy Code itself. The Supreme Court has really championed that legislation and put a legal matrix which is very sound today, and possibly one of the most sound legal matrix that we have in the world on insolvency and bankruptcy. You had the Swiss Ribbons judgment where the Supreme Court upheld the validity of the Act and indicated that it is in the interest of resolution rather than liquidation that the Act has been brought in, etc., etc. So the general tendency of the courts is not to interfere in economic legislations very easily. But see what the Supreme Court has done here. The Supreme Court is very clear. It is not indicating that the Reserve Bank does not have powers as a regulator of the financial sector. Not at all. It has all powers to regulate the financial sector. But what was the Reserve Bank doing? It was not just regulating the financial sector, or in the garb of regulating the financial sector, was actually insisting that the banks who have a relationship with the debtor will necessarily take the debtor to the IBC process. So the law was amended not to give any additional powers to the Reserve Bank of India over and above the discretion that is vested in the banks to take a particular entity or not take a particular entity through the IBC process. The power was only given to the Reserve Bank of India through, of course, the notification of the central government to say that in specific cases, for example, I'll take an illustration. Let me assume that I have a large debt going on and my company is in doldrums, and there is no way that I will make sure that there is rectification methodologies brought in. But however, the bank, the board of the bank and the chairman of the bank are my best friends, and therefore they are never going to take me through an IBC process, which means that as a sector issue, as a sector regulator, the Reserve Bank had no power to mandate the banks to say that, listen, in this case it is egregious and you necessarily have to take the person to IBC. However, that vacuum is filled in where, despite all egregiousness existing, the banks don't take a particular action in a particular case for whatever reason, whether it is genuine reasons or whether it is extraneous reasons. Then the Reserve Bank can step in to say that in that specific case you will take action. So don't look at the section as a section giving extraordinary powers to the RBI. At the same time, don't look at the judgment of the Supreme Court as curtailing the powers of the RBI. RBI had its powers as a banking regulator, no doubt about it. However, it did not have overarching powers which it thought it did under the Act, and therefore the circular which is actually overarching being struck down is actually bringing everything back to focus.
Okay, Mr. Puvaya, you made an interesting comment. I'm going to take it to Nilang for a reaction. Nilang, Mr. Puvaya says that the RBI hereon will have to intervene in a specific fashion. So where a bank is, not taking a corporate debtor to insolvency, even though the circumstances require it to, the RBI will have to step in and say so. This is an exercise of incredible discretion on the part of the RBI that we're expecting, and could be by many as, called counterproductive. We don't want the Reserve Bank going around telling banks, hey, that account needs to go to insolvency, X account needs to go to insolvency, Z account needs to go to insolvency. What the Reserve Bank had done previously and in this circular had put in certain parameters and said if you don't meet these parameters, you go to insolvency. Now those general parameters don't function anymore thanks to the Supreme Court. Are we expecting the Reserve Bank of India to be more specific in exactly which corporate debtor should be taken to insolvency?
I don't think that's how things will play out. I think what the court has said very clearly that to use that particular section, which is 35AA, you're right, there needs to be a specific default to the specific debtor, but also says that it has to be with the instructions of the central government. So this is not the RBI walking about saying, here's X company, here's Y company, put them into IBC. That's not what the RBI does. It's not what it would do. And frankly, I think that the Supreme Court is saying it cannot do. That it can only do with the central government direction.
But Nilang, that's even worse. Now we're expecting the central government to exercise discretion on X company should be taken to insolvency and Y company should not.
I agree, and I don't think that's going to be very forthcoming. So, in fact, I'll echo the comment you made that it's ironic the way this is played out, that this very technical interpretation has been taken off sections 35AA and 35AB, because the Supreme Court itself admits that under 35A, which is the old section, it thinks the RBI did have power to push a generic circular requiring that a whole bunch of companies meeting objective thresholds go into IBC. So it had that power. And I think, as you said, when 35A and 35AB came in, the thinking was that, listen, we think it has the power, but just so that there is no constitutional challenge against its power to do so, let's be a little more specific. And at least my understanding then was these sections came in to be a little clearer about RBI's ability to go forth and exercise this power. And I agree, I think it's a little ironic that 35A has been read in such a way which actually circumscribes the RBI's power. Now, it is what it is. That is how it has been read. I see the technical reading and the technical evaluation of this section, but I think we have come to a position that might not strictly have been intended in my personal view.
Okay, that's a fair point, and I'm going to take that back to Mr. Puvaya. Mr. Puvaya, for a moment, take off the hat where you were representing the power sector, etc., and give me a response to Nilang's point and the point that I'm trying to make as well, that if it has to be a specific direction from the central government to the RBI in a specific case, then we're now asking both the central government and the RBI to exercise individual discretion or discretion in the matter of individual cases, which definitely cannot be what the intent of this was. So are you suggesting that unless, that any kind of general parameters would not be acceptable and that, therefore, here on the RBI, for all practical purposes, has no powers to tell a bank to send a company or a corporate debtor or a defaulter to insolvency?
I think we should look at it, we should step back and look at it in the context of how the various legislations operate. Now, don't look at the Banking Regulation Act just separately as an artificial island of regulation when it comes to a debtor-creditor relationship, and then look at whether 35AA says X, whether 35AB says Y, whether 35A in its original form covered it, etc., etc. Now, let's just look at it in terms of its practical implication to the scenario today. we have multitude of stressed assets. I'll just take power as an example. 2.5 lakh crores worth of assets that are stressed in the country. Now, how are those stressed assets to be dealt with? We have an insolvency bankruptcy code, possibly one of the best legislations that we have got in recent times. The insolvency bankruptcy code provides a methodology by which these stressed assets can be resolved. Nobody is really finding fault with that. But it also rests, or in some form or the other keeps at the threshold of the banks the discretion for the banks to actually take a particular debtor through the insolvency process. It is for the banks to take that determination because they are closely dealing with the debtor. They know what indications have, or what reasons have gone behind the particular episode for the debt to actually become stressed, etc., etc. So that discretion is always with the banks. A bank may, the wording in the section in IBC is that the bank may actually initiate a resolution process under the IBC for a particular debt. Now, that law exists. Now, overarching and in addition to that, you bring in an amendment to the Banking Regulation Act where you take away the discretion from the banks. The bank may do so under the IBC, but I, under 35AA, the RBI, I am not the bank, but I am the regulator for the banks. I will now ensure that you will do a particular act, although you may in your discretion choose not to do it. Therefore, there is some sort of a dichotomy here. You leave it to the banks are actually taking the process. If you as a regulator, the RBI, believe that a bank is not doing a particular action in a particular case, then go ahead and exercise the power. Now that power is not given to you under the Banking Regulation Act automatically. That is given to you under 35AA with another safeguard or a safety valve which says that the central government will first notify, and based on the central government notification, you as a regulator will exercise your powers. That's the law. Well, now, I don't think we can go behind the legislation to saying, oh, would the central government issue a notification? That's the amendment. The amendment says so. Now, what happened? Why did the trouble start? The trouble started simply because there was one notification by the central government which said, here RBI, I am authorizing you under 35AA to go ahead and pass circulars or notifications. And the RBI said, I will issue one circular for the entirety of the country, for every sector which is conceivable, and indicate that so long as the debt is over a particular number, you will necessarily take the party to an IBC process in 180 days. It is in that context that the judgment came up. So I don't think we should read the judgment out of context. In my view as a lawyer, irrespective of who I appeared for, that is irrelevant when it comes to the law. I think the judgment is extremely clear that it does not scuttle the powers of the RBI that existed. It only indicates that 35AA does not become some sort of an overarching clause which gives all residual powers to the RBI to become some sort of an imperium in imperio regulator, saying irrespective of who you are, I am the regulator and I will force you to do so.
Mr.
That's
Puvaya,
the context in which the judgment has come.
I
genuinely think that it is a well-reasoned judgment.
Mr. Puvaya, on ordinary days it's difficult to argue with you the excellence of your argument. On a day that you won, I hesitate to do so, but both the alternatives that you've presented to Nilang and me are not necessarily very desirable alternatives, because the honest truth is that banks have not been very forthcoming in taking corporate debtors to the insolvency route. And if it weren't for the push of the RBI, I'm not sure that we would have seen as dramatic a change in our credit culture as just by the standalone effect of the IBC. Nilang, am I correct in that?
I do think that the RBI circulars have helped in speeding up NPA resolution than otherwise we would have seen. And I do think that has caused the activity, the industry, the influx of foreign capital. So all of the things that the RBI has done so far has had some good effects. Has it also had some bad effects? Possibly. But then in a country like ours, it's practically impossible to do something which only has good effects.
What kind of bad effects, Nilang? Would you be able to illustrate that?
I think Mr. Puvaya is pointing out there will be instances, there will be borrowers who were caught in a bad cycle, in a bad time, with bad supply, etc., and who may justifiably have needed more time. And frankly, giving them more time may have got a better result for the banks. But the problem is, I think as we said earlier, the RBI can't say of these 20 cases, I'm going to say 7 go into IBC, 13 don't.
Yeah.
So it's inevitable for any law which does good to do a little bit of bad or a little bit of unexpected bad.
Yeah, fair point. I think the second alternative, Mr. Puvaya, that you presented in front of us, one is to wait for the banks to find the initiative to do so. So far, the record hasn't been that, but now the banks are on their own, so hopefully they will, sort of do so or rise to the occasion. But the second alternative is exactly what bothers me the most, which is that if we're waiting for specific directions from the central government and specific directions from the RBI, then we've got ourselves into a bit larger mess than we had anticipated, because then it's going to have to be to choose between companies. Imagine having to choose between, let's say, a private sector power company that has, sort of not been able to repay debts for a variety of other reasons, and another public sector company or somebody else in the process, where you are having to now select as a central government and an RBI whether I should send X to insolvency or not and Y to insolvency or not. And I think that's going to be sticky. But what's going to be stickier, and I want to get your view on this, before the Feb 12 circular, in the year of 2017 itself, the Reserve Bank of India, on the basis of the original ordinance, had sent 12 companies first to insolvency and then another 30 companies to insolvency. Now, the selection of these 12 and then the 30 were based on certain size parameters, right? And I'm just wondering, while the Supreme Court is very clear that what they've struck down is the Feb 12th circular, because they found the RBI's use of Section 35AA too wide, do you think that there could be the case that those 12 plus 30 companies or 42 companies might now be able to agitate against the RBI directions that force them to go into insolvency?
Interesting that you bring it up, and I'll answer that. I don't think there is a problem with it. But before I answer it, please permit me to take 30 seconds to indicate. The irony, I agree with Nilanjan that there can be a byproduct which is sometimes bitter when you actually bring in a reformative legislation, be it in the economic sector as well. But Menaka, kindly look at this. You gave an illustration of saying that let's look at power sector. No, you have 2.5 lakh crores, I said, of stress assets in the power sector alone, of the 11 lakh crores which the banking sector overall has, the banks have overall across all sectors. Now, but this 2.5 lakh crores of stressed assets, believe me, are completely in the private sector and not even one in the public sector. Now, that's because from a rationality perspective, you have a regulatory regime that is so topsy-turvy, which is so well oriented towards the public sector and not the private sector. How is that in an ecosystem that you will have all private sectors doing badly in power, but not even a single public sector doing badly in power? In fact, if you look at anything else, manufacturing, it's the other way around. Every public sector is doing badly and every private sector is doing well. Now, when you have a regulatory regime which is topsy-turvy, and you overarchingly bring in another specific legislation say that you will necessarily take people to the insolvency process irrespective of their conduct in the default, then it becomes absolutely arbitrary. Now let me give you the example of the dirty dozen which you brought out. That's the 12 cases that were brought in prior to the February circular. Now there's nothing wrong with it, because our case was that please exactly do what you did in 2017, in 2018. The February circular in 2018 said what? It said that if you have a debt of more than 2,000 crores and it is not resolved in 180 days, you necessarily shall go through the process, the guillotine of the Insolvency and Bankruptcy Code. That's what it said. Now, that was under 35AA. Now, the same Reserve Bank of India in 2017, under the same 35AA, when it looked at larger debts, that is 5,000 crores plus of debt, which are stressed assets, they did not say that everybody who has more than 5,000 crores debt, which is stressed, in 180 days, if you don't de-stress, you will necessarily go to IBC. They appointed a committee called the advisory committee. That advisory committee looked at all cases. Each one was picked up and examined. And out of the multitude of cases, 12 egregious cases were chosen by specificity and by name to saying that these are the companies that must go to IBC. You didn't make a one-size-fits-all approach in 2017. You took the pains to identify the bad apples and separate them from the apple cart. Why didn't you do that in 2018? Because you found it more difficult. So you say you push the entire apple cart into the resolution process. What happens to the good apples simply because they are stuck with the bad apples? Now that, I think, therefore, the present judgment which said that the exercise of power in February is bad, that's the circular which is struck down. It does not strike down 35AA. It does not say 35AA is bad. Therefore, the exercise of power pursuant to a notification of the union, of the central government, by the RBI in 2017 for the dirty dozen 12 cases of 5,000 crore plus, according to me, is perfectly valid law.
Nilang, would you agree with that? That the promoters of those companies, the dirty dozen, some of them have now already been through insolvency and have found, successful resolution, but the SRs, etc., are still pending. Do you think that the promoters of those cases, those 12 and then subsequently the 30 in the December of 2017 that were also to be referred to insolvency, now have a defense and now have the ability to maybe move the Supreme Court and say, hey, look, we find that in our case also the application of Section 35AA is general and not as specific as it ought to be, and the central government did not name us in any fashion. The committee that looked at it was an RBI committee, so there's no central government direction specifically against us, and therefore we should have never been pushed into insolvency to begin with.
I'm going to give you a boring answer. Unfortunately, my firm represents the RBI, so I'm not going to comment on that. But I will say this much, that I certainly think a lot of people will be thinking about the same point you just made.
So I am correct in saying that maybe the door isn't open, as Mr. Puvai has pointed out, but there is a window open.
I think a lot of people will be wondering whether they can make this argument.
Yeah. Mr. Puvai, do you think that we're setting ourselves up for more litigation? I know you just made the point that you don't think that they have grounds, but the way this judgment reads, I think that there will be at least, a dozen companies right now and their promoters who are finding heart in this judgment and saying, hey, no central government direction was specifically against me. The RBI, yet pushed my bank to send me to insolvency, and I'm going to agitate against it.
Fortunately, litigation or quantum of litigation in this country is not regulated. Fortunately, we don't have quantitative restrictions imposed on the amount of litigation that can be brought. Therefore, I'm sure, see, let's look at it this way. I think you are entitled to raise every argument available to you in the law and fight it in courts. That's the beauty of our legal system. So when a judgment, and in my view, a perfect judgment is rendered by the Supreme Court in terms of a particular circular, will that have manifestations and ramifications and generate litigation as a byproduct? Obviously, yes. When the privacy judgment was rendered, the world celebrated India's privacy judgment. But everybody said the byproduct therefore will be that everybody will now start litigating, saying, hey, don't ask me for Y, don't ask me for X, because I have a fundamental right to privacy.
Okay, let me
now,
rephrase.
Because you have a byproduct of litigation, can you turn up and find fault with what's happening?
Mr. Puvai, let me rephrase my question. Do you think that the promoters of any of those companies that have suddenly turned hopeful today will actually stand a strong chance in court in using this judgment in their favor, especially if their insolvencies have not yet reached fruition?
Hope is a matter of the heart, madam, but the law, I think, will be a matter of reality. Now, will they have hope to say that, okay, this judgment gives me 2 lines in page number so-and-so, therefore I can file a writ petition? Obviously, yes. Somebody will actually find hope when nobody else does, and therefore a writ petition will come to be. But would that lead itself to a scenario like in the present case, the February circular has been struck down? My answer is no. Because when we challenged the February circular, it's not that we didn't examine what the RBI did previously. Why is that none of those cases really were challenged? Why is that only the February circular under 35AA was challenged and the previous 2 exercises of the RBI under 35AA was not challenged? That is because there was rationality brought to bear by the Reserve Bank of India in the previous exercise of power. That rationality was missing in the present exercise of power, and therefore it was challenged from May in Allahabad to various courts in the country to then to Supreme Court, and finally a judgment now in April of 2019.
All right. Nilang, I'll give you the last word on this. Do you expect this to have a dramatic impact on the number of cases going into IBC, as in a reduction in the number of cases going into IBC? Because the pressure's really off, right? Why even today, even Jet's lenders will probably be celebrating. Again, that's a case your firm is handling, so you won't comment on it. But they'll probably be celebrating that the 180-day deadline is now off their necks. And then they can take longer to be able to try and resolve that airline's problems without having to push it towards insolvency. So there are a large number of companies, their promoters and banks maybe heaving a sigh of relief, but it also means that there are fewer cases that will go to insolvency?
I certainly think there will be fewer. I think there will be some market players who will argue that fewer may not necessarily be bad. It will reduce the pressure on the system. It will give banks more time to process their bad assets and, provide diligence and discuss with players to buy those debts rather than going helter-skelter, running from COC to Swiss auction sale process, etc., etc. But I think that the hope is that despite there not being a guillotine issued by the RBI, that just cases are taken to the IBC in a sensible amount of time. And really what we need to see is whether that happens or not. And if not, that's a tragedy.
Well, unfortunately, banks someday had to grow up and be able to make their own decisions without the RBI prodding them into those decisions. Gentlemen, thank you very much for throwing light on the implications of this Supreme Court decision. Mr. Puvaya and Nilang, thanks for joining us here on Bloomberg Quint Live. And thank you all for watching. I hope you have now understood clearly what the implications of this Supreme Court decision are.